Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Hello, hello, hello. Welcome back to my kitchen. Lisa Figalicious in the flesh. Nice to see you, my friend. Kay Crimson is here. What a day. What a day. What a day. I'm so excited, you guys. Hi, Trish. Trish is back. Martha's here. Greenwald Renee. What a day. It's going to be great. We are making stuffed mushrooms today. This recipe is cheap and easy. What? Yeah, that's sort of my style. And you can make it along too. Just watch me do it. I just washed my hands, and we're gonna get started here. I have all my ingredients out that we need, and I actually set up a little chopping station so that everyone can see me do my chopping. Hopefully I don't cut myself. That would be hilarious, right? Set that up and then just proceed to butcher myself. Not good. Yeah. Oh, my dinner last night was very good, and it is, I had to resist making these mushrooms last night to take. Oh, that's the other thing. I was gonna make this in the air fryer, but it's actually really hard to get out of the air fryer. So we're gonna bake it in the oven. So I'm gonna turn the oven on to 385. A very arbitrary random number. Hi, Casey Carey. And we're gonna bake them in a thing so that I can pull the pan out easier and show you. When you're making them yourself, the air fryer is fine because it doesn't really matter how they look. But, you know, if you're doing like a mock cooking show on the internet, you might want to make them look a little bit better. Does anybody else store things in their oven like I do? Hey, wait a second. Do. Thanks so much. Reseller Road Trip Adventures. You're heading to the mountains, did you say, by the way? With your tent and a dog. Wow. That sounds great. I can't click on them and bring them up on the screen right now. Well, first of all, but thank you. Have fun. Be safe. Secondly, warming drawer. I was told that the bottom drawer of the oven... Wait, did it happen again? I see it twice on here for Reseller Road Trip Adventures. YouTube Daddy's going a little crazy, but thank you. And then Casey Carey gifting memberships. Thank you. Am I the only one that sees that twice for Reseller Road Trip Adventures? Anyways, waiting for the cruise, baby. We're gonna do it. It'll happen. We're also watching Court today. Thank you guys so much for the memberships. That's on Sundays. Cindy, woo! You're home. Everything came out good, you think? On cosign, I think. I don't know what that means. Thanks for the prayers and well wishes. Well, we're still praying and we're well wishing for you, Cindy. And I don't know what cosine is. I mean, I remember it vaguely from math, and I didn't pass. I'm sorry. So I can't help you there with cosine. Yeah, I saw it twice too, reseller. That's so weird. No, seriously, I'm joking, but that's great. Oh, codeine. Oh, I know about codeine. Oh, yeah, I know about codeine. Enjoy. We love you, Cindy. I hope you're doing well. We're gonna have, like I said, stuffed mushrooms. So let's get started with court just cause, and then we'll get going. The first thing we're gonna do is turn the oven on. Done. Second thing we're gonna do is prepare the mushrooms. So I'm gonna tell you this now, and then I'm gonna do it. I'm pulling all of the stems out of the mushrooms, and the stems of the mushrooms are going to become the filling that goes in the mushrooms, part of it. So that's the first step that we'll do as we watch some court. Oh, hold on. Hold the phone, please. Okay. If there was any beyond. Here we go. I think it's going to take her a minute.
Taking a moment to go live.
That's what I thought. It would take her a minute. Also, let's go over the prices for this. These mushrooms were finally on sale for $1.77 Canadian for the pack. And they're not that big though as I look at them, but I mean you can't be picking. No, I'm just gonna get it. And then yeah, the recipe is very cheap. Cheap. Ma'am, can you figure this out? No, apparently not.
This man
Against her to push
on the side.
There we go.
37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2021-981 DM Zachary French versus Elizabeth French. Today is Monday, September 30th, 2024 at 9:01 a.m.
Court will note the appearance of Mr. Bailey on behalf of the plaintiff, Mr. Zhang on behalf of defendant. This matter is before the court on the defendant's motion to set aside the referee recommended order of August 13, 2024. Mr. Zhang.
Good morning, Your Honor. I will rely on my pleadings, but I would like to point out that it took a lot of courage for my client and a lot of therapy for my client to start talking about the abuse she observed or she endured from Mr. French, and for the referee to use it against her to punish her essentially for trying to speak up. I think it just set us a bad precedent for the future. It's discouraging the domestic violence victim from speaking up in the future. Furthermore, neither party has asked for a changing legal custody, and it is very inappropriate for the referee to essentially initiate a changing legal custody without either party asking for it. And third, regarding the school issues, the referee very much solely focused on just the academic records of standardized testing. And yeah, that shouldn't be the end all be all of all evaluation when it comes to school. Whether you have family in the area matters. Whether you have people who you're familiar with who went to a school, who went to the school.
Christopher Engleby, punish you. All right. You don't have to twist my rubber arm to do that. Also, hi, Flusha. These two mushrooms walked into a bar, ordered drinks, and bartender says, "We don't serve your kind here." Mushroom says, "Come on, I'm a fun guy." I like that. Hi, Chris, and hi, Flusha. We are making stuffed mushrooms today. These ones are too small. These ones are too small. That's okay. We'll have enough. I hope everybody's doing well. This case sounds a little... I hadn't listened to any of it ahead of time. You know me and my preparation. And so, oh my god. I raised the chopping board up on this thing and things keep falling off of it. I'm laughing. Oh right, I have these ones. These are bigger. Anyways, That does sound a bit much to me to change the schooling if nobody asked for it on behalf of the friend of the court. Crock pot in the chili. That sounds delicious. Chris, we should do a chili recipe cook-off. Although we couldn't judge them. I mean, we all have to make them ourselves. But anyways. Okay, mushrooms are prepared now, so we're gonna chop those up, then we'll chop up and we'll keep listening. We'll see how we do.
Who are familiar with the culture and with the community of the school matters to also. And it is referee has erred in not considering that or minimizing the effect of those factors in making his decision. Thank you, Your Honor.
Okay, thank you. Mr. Bailey.
Yes, thank you, Your Honor. Regarding the pleadings, we're going to rely on referee Croteau's referee findings. We had 3-day evidentiary hearing. We had witnesses. We had exhibits. We believe he did make correct findings. Regarding Mr. Zhang's allegations of credibility being a big issue in this case, they were, but they weren't the sole issue in this case. This didn't decide school district or custody alone, but credibility was a big part. And Ms. French did not have any witnesses to corroborate her stories, and her stories changed at multiple points of these proceedings. They were never brought before your attention at the divorce trial. They were brought up at a CPS investigation, and then the stories changed over time.
My story's never changing. Chris, I love you. Thank you so much. You are so sweet. I'm putting all these mushrooms back in this container so that I can put the chopped stuff in here. Who got the gift? Was it William? Who got the gift? William got the gift from Chris. Thank you, Chris. Also, shirtless dad, you're hungry? Well, I'm about to have some mushrooms ready.
Regarding legal custody, although legal custody was not requested to be changed in a pleading, Mr. French did make oral presentation at the referee hearing that if the court found fit, he would take sole legal custody of the minor child. And regarding the school, while academic records were presented as exhibits and Ms. French failed to provide any witnesses or any exhibits about Ellsworth schools, Mr. French also had an expert witness from Michigan State, from the preschool, who was able to talk about the transition to Hazlitt schools for young kids, how the children get to have their instructor at Michigan State directly talk with the instructor at Hazlitt schools. And so it wasn't just academic records, it was transitions for children from preschool to kindergarten, and it was about the other surrounding benefits of the Hazlitt area. So, Your Honor, we don't necessarily have a right to object to Ms. French requesting a de novo hearing, but we believe 3 days of evidentiary hearing in a very thorough record, very thorough transcript, and very thorough findings are satisfactory for the custody, parenting time, and school districts of this minor child. Thank you.
Okay, thank you. Anything else, Mr. Zhang?
Yes, I'd just like to point out that the expert I was spotting from the MSU preschool was not she was not part of the Hazlitt School District, and she was a program that Mr. French unilaterally enrolled the minor child in, claiming to be a child care program, and later turns out to be a school district, or not a school district, but some sort of a preschool program, and that was not consulted with my client, and that and for Mr. French to be able to gain advantage by bypassing the joint legal requirement before the sole legal issue was changed, I think it's just inappropriate. Thank you, Your Honor.
Okay. Well, the court has reviewed the file thoroughly. I've reviewed the referee's finding as well. And obviously the defendant disagrees with the referee, but that in and of itself does not establish error simply because you disagree. The referee did find the plaintiff to be more credible in this case, and credibility is always an issue, goes to a lot of the factual issues the referee found, and that the plaintiff had presented more compelling evidence than that of the defendant. And that doesn't in any way attempt to minimize, or as Mr. Zhang says, punish her for coming forward. But the fact is, when the referee is presented with more compelling evidence on one side, he has to consider that. And he did in this case. The court, when I review this, I do not find that the referee made a factual or legal error in this matter, and therefore the court is going to deny the motion in this case. Mr. Bailey, you can do an order denying the motion submitted under 7-day notice. Thank you. You're free to go. Have a good day.
You too, Your Honor.
Thank you, Your Honor.
Thank you.
Judge, next case is going to be Coolidge versus Hankey. Is your client appearing this morning?
No, he's not, Your Honor. So I am attending on his behalf.
Calling case 2014-1428 DS Samantha Coolidge versus Jared Hankey. Today is Monday, September 30th, 2024 at 9:08 a.m.
Court will note the appearance of Mr. Bland on behalf of plaintiff, Ms. Henderson on behalf of defendant. This matter is before the court on the defendant's motion to show cause. Ms. Henderson.
Thank you, Your Honor. Unfortunately, this is defendant's fifth motion to show cause. I would ask the court to remind plaintiff she still has an outstanding warrant for failing to attend the previous hearing. At this point, she continues to deny the parenting time to my client. Most recent denial occurred as recent as last week. At this point, we're asking for the court to schedule another in-person evidentiary hearing to which the plaintiff should bring the child, and the child would be in a conference room with an adult during the hearing. Otherwise, my client is not going to get the child. We're asking for her to be held in contempt. We're asking for the bench warrant that is currently out for Ms. Coolidge's arrest to be modified to be extraditable. For court's information, my client is in the process of domesticating the orders of this court in Indiana, but it does take some time, unfortunately, and Ms. Coolidge continues to deny him parenting time. We're asking for makeup parenting time of 6 overnights and 8 days. We're asking for attorney's fees, Your Honor. At this time, plaintiff has not made any payments on the fees she's already been ordered to pay. So in lieu of receiving the payment, we're asking that my client get credit for a total amount that has been ordered for Ms. Coolidge to pay, as well as the current attorney's fees, and to set it against any child support obligation that my client would have. Otherwise, he will never get paid by plaintiff. We're asking for in-person evidentiary hearing to address all of those issues, and we're asking that the child be presented for that hearing. Thank you.
Mr. Bland, are you contesting the matter, so you believe we need an evidentiary hearing? You're muted, Mr. Bland.
I apologize.
Nope.
Yes, Your Honor, we are disputing those matters.
Okay. In that case, the court will hold an evidentiary hearing. The court will do that again in person. In this case, the plaintiff will have to be present for that. And the court will order that she bring the child as well to that particular hearing so that the child's available to the court.
Judge, I would note at least that she wanted me to indicate that coming to Michigan is a hardship for her.
Mr. Bland, I don't care what her hardship is or problem. We've addressed that. She'll appear, or otherwise we will have her extradited and put in jail. That's her choice.
Holy shit. Judge Wordle is not impressed with this lady today, and he doesn't like Anya very much either, so that's impressive. Also, thank you, Christopher Engelby. Why didn't that beep? Streamlabs, why didn't you beep when Chris donated? Thank you, Chris. Congratulations, Hector. Also, if you noted, I just chopped up a little bit of onion and garlic and put that into the mix as well. So, all chopped very finely, like as if I went to culinary school. And now we will add in some herb and garlic cream cheese. And, oh, but we're gonna start with my mushroom ketchup. This is basically like a Worcestershire sauce, but it's made of mushrooms, and it is, I'm going to be mixing it, Bill, lots. But anyways, this is the, what I add to it. Oh, fuck. Sorry, my sister just texted me. So we're just going to add a little bit of that in. That's actually quite a bit of that. You start your vacation on Monday, Chris? That's awesome. So we've added that in. It's a little wet now. Everybody loves being a little wet. And then we're going to add in a little bit of this garlic cream cheese. You don't need that much, actually. That's probably enough. And then I'm going to stir it together with a spoon. Judge is he's in a bad mood from this lady, but you can't not show up to court, lady. Come on now. Come on now, get together. Get it together. And then we just start mixing this, and it'll loosen up a little bit. It's also what he said about her. And then this is what we will, oh, I forgot. Normally, you put other cheese in this, you guys. I'm on a diet. I'm going to eat this myself. So I'm leaving out the extra cheese. But for you, if you're making this like to take somewhere for an appetizer, add some cheddar cheese to this part. Oh, yay, it finally happened. Thanks, Streamlabs. Add some cheddar cheese to this part as well as on top, okay? But I'm going to leave that part out because I'm going to house all of these later. And I don't need the extra cheese because we're going to put a little on top anyway. So, sorry. Lucky I'm the only one eating here at this restaurant. Oh, for God's sake.
I'm not trying to quarrel with you, Your Honor, just indicating.
I understand. I'm just telling you.
That happened to my client.
I understand. I'm just telling you what's going to happen, or otherwise she'll find herself in jail.
Thank you, Your Honor. Would the court like me to prepare that order, or will the court be sending the notice with the date?
We'll be in touch with both your offices and set up a time when you're available.
Thank you very much.
Okay, thank you.
Thank you, Your Honor.
Have a good day.
Thank you.
Anya, I will call your next case, which is Joswiak.
Bye, Chris. Love you. Also, Sherry, we're cooking stuffed mushrooms. I forgot
Calling
to add
case
pepper.
2021-776DM, Chelsea Joswiak versus Ryan Joswiak. Today is Monday, September 30th, 2024 at 9:13 a.m.
Court will note the appearance of Ms. Henderson on behalf of defendant. This matter is before the court on the defendant's motion to hold plaintiff in contempt and request access to various passcodes. Ms. Henderson, did you get the answer in this matter? What she stated she had provided those passcodes?
We did, Your Honor. Unfortunately, the children's phones have two sets of passcode. One is to actually unlock the phone, and the second one is to the parental controls. That issue has been followed up on with Ms. Joswiak upon having received the initial passcodes. Ms. Meredith Katz also weighed in on that issue on Friday, stating that both parents must have access to those parental controls as they need to monitor the screen time, the apps and websites that the children visit. And it's not just the parents' right, it's their obligation to monitor that. Ms. Joswick vehemently refuses to produce those passcodes. She states that Ryan can get the children their own devices to use at his home, or that he has to pay 1/2 of the bill. Again, Ms. Meredith Katz weighed in on this, stating that it does not matter who pays for the phone. It matters that both parents have equal access to the parental controls and that they're able to monitor the screen time limits and things of that nature. Ms. Joswick is receiving child support that can be used to pay the bill. It's not an issue of who pays the bill. It's an issue of each parent has the right to access that. And it should be noted to the court that the children are currently spending more time at Mr. Joswick's home due to him exercising the makeup parenting time he has been granted. So it's absolutely fundamental that he has access to those passcodes. Because Ms. Joswick vehemently opposes providing those, we're asking for her to be held in contempt, as this is a refusal to follow recommendations of Ms. Katz that both parties are to follow pursuant to a court order, and we're asking for attorney's fees in this matter. Thank you.
Okay, thank you. Ms. Joswiak, you're muted. You'll have to unmute and then respond.
Okay. Can you hear me?
Yes.
July 26th was the last time I had any contact with Meredith Katz. She has not involved me in any of the meetings, any conversations. I knew nothing about a conversation pertaining to the kids' cell phones. I received an email September 6th telling me that I needed to hand over the passcodes. And at the end of the email, Meredith clearly states if you have any questions to reach out to her. I did. I responded that day with an email asking several questions about my children's safety concerns, if anything had taken place that I should be aware of, as to why Ryan needed the passcodes to the phones. I don't believe it's for good intentions. I believe it's to read conversations between me and my children. However, I never received any answers to any of my questions. It was kind of passed to the side, and I complied anyway by giving him the passcodes to the phones, so he is able to enter the phones. He is able to see what they're doing. The kids do have downtime on their phone. They do have app limits. They do have contact limits. Communication safety is on. Content and privacy restrictions are on. As far as the codes, not giving codes on the contact limits and app limits, those phones are linked to our Apple Cache and our iCloud. So I don't believe Ryan needs those passcodes. I also think this would be a great opportunity for Ryan and I to co-parent by deciding the limits together, and not Ryan putting limits at his house and then Chelsea changing the limits when they get to my home. That's something we should decide together. I never refused to give any codes. I simply asked questions I had no answers to. And I'm not trying to undermine anything that Ryan's doing, but rather work together instead of running to Meredith every time that there is an issue between us that involves the children, as I am no longer included in anything that is happening.
Okay, well, I don't know where the breakdown was with Ms. Katz, if there was, but you have a right to request that. And obviously it's stated that the parties would continue counseling with Meredith Katz and would follow the recommendations. And I don't think that Mr. Joswiak's request on having access to those phones is for any ulterior motive or anything other than for the, again, the supervision, monitoring of the children, which is important. So the court is going to order that all passcodes as necessary for him to monitor their phones would in fact be provided within 7 days of today's date. And so they would have access to those. The court would, at this point, I'm just going to reserve on attorney fees pending any further proceedings in this matter. And with that, anything else, Ms. Henderson?
I don't believe so, Your Honor. Thank you.
Ms. Jazwiak, anything else?
No.
Okay, you're free to go. Have a good day.
Thank you.
Thank you.
Next case is Taft versus Murphy. Calling case 2023-1722DM Kimberly Taft versus Scott Murphy. Today is Monday, September 30th, 2024 at 9:19 a.m.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff, Ms. Capture on behalf of defendant. This matter is before the court on the defendant's amended motion for relief from judgment and motion to modify judgment of divorce. Court notes I have received and reviewed the answer as well in this matter. Ms. Capture, you can proceed.
Thank you, Judge. First and foremost, I just wanted to be stated for the record that we came before this court a few months ago on our original motion to set aside the judgment of divorce.
Ms. Capture, I don't want to interrupt you, but you don't have to give me all the background. I'm well aware of it. I've reviewed the file in preparation for today.
Thank you, Your Honor. All I want to say is that my client would have no reason to say what he did at the pro confesso hearing if not for the 2-hour, 3-hour conversation that he had with Ms. Taft discussing the terms of the judgment of divorce, where she continually stated that she was fatally diagnosed. Again, Your Honor, we've been here before. I've stated this before. I wish no ill will on Ms. Taft. However, the fact of the matter is that my client entered into a judgment of divorce under the presumption that circumstances would be different at this time. Also, I just want to address specific things stated within Ms. Taft's answer. While she states that she never directly told Mr. Murphy not to have an attorney, she would often utilize the children. She communicates through them very frequently. She utilizes them to induce Mr. Murphy into complying with what she wants. So for instance, she would communicate that, Mr. Murphy shouldn't have an attorney, and they would talk to their father stating, we're really upset that you have an attorney. You should get rid of one. Mom already has an attorney. She also utilizes them when it comes to parenting time exchanges. She will initially try to communicate with Mr. Murphy. If he doesn't agree with her, she will then communicate with the minor children. A great example of this is an exchange location. Recently, the parties were trying to exchange the minor children. Ms. Taft violated the agreement twice. Mr. Murphy then stated, well, I'm not going to go by your agreement then if you're not going to follow it either. Then Ms. Taft called the minor children, who then coerced Mr. Murphy into, or convinced Mr. Murphy into going by the agreement. This is a repeated action. Unfortunately, these minor children are being caught up in divorce and post-judgment proceedings because Ms. Taft continues to include them in this. For instance, as we stated in our motion, Mr. Murphy has continually tried to work with Ms. Taft. He did not get the overnights on 6:30 through 7:2, 7:7 through 7:9, 7:14 to 7:16. Even though it's stated in her answer that he did get those, he didn't. He was trying to work with Ms.
I want to interrupt you now, but how does this go to your motion? You're bringing up all this extraneous stuff. Doesn't go to your motion to set aside the judgment.
Well, Your Honor, our motion is to set aside the judgment and in the alternative to modify the judgment of divorce pursuant to all the reasons stated in our motion. The first portion of our motion is to set aside pursuant to our original motion that we filed. And then the second portion is to state that in the event that you don't want to set it aside, that we at least modify it to comport with the changes in that Ms. Taft has not complied with the parenting time agreement, has not complied with the expenses agreement, which Ms. Taft states in her answer that it's actually Mr. Murphy that keeps shutting off the card. In fact, the agreement by the parties is that they utilize that credit card for all extracurriculars, and instead Ms. Taft charges her personal cell phone, all the groceries and gas on that card, and frequently maxes it out, which is why it's allegedly being shut off. So, Your Honor, again, there's numerous inaccuracies stated in this answer, and so we're asking for either the judgment of divorce be set aside, or that we modify the judgment pursuant to our requests to incorporate the changes that we need. Thank you, Your Honor.
Thank you. Mr. Schaefer.
Your Honor, this is a motion to set aside the divorce judgment under Rule 2.612. And it certainly goes astray in a lot of ancillary ways that I don't think are relevant to that issue. Our position, there was no pressure. How does one pressure somebody not to have an attorney? And then we hear today new information not pled about influencing through the children, which is not supported in the pleadings or anything else. This is a remake of the prior motion. There's no new information herein. The only thing that they attached was the testimony from the pro-con. And again, the judge recognized that. The judge indicated that he was convinced that he approved the judgment, he understood it, and he signed it. This is an agreement that they negotiated, that it went into effect, and there's nothing in here of any sort of fraud at all. Even if you believe that there was a diagnosis, now the complaint is she didn't die. I mean, that's pretty draconian at best. And but that was not made. He made his own decision as to what he entered into, and it should be denied, and costs should be awarded to my client to have to go through this process a second time. We've answered all the other extraneous stuff, and I think it's a pure retaliation for the reason that the defendant has been charged with domestic violence. He has a PPO coming up later, so this is striking back out, trying to retaliate. We ask that it be denied and that reasonable costs and attorney fees be awarded.
Okay. Anything else, Ms. Capture?
I have not.
Is that actually true, Mikey? Were you really on the phone with Judge Fleischer? Lucky Judge Fleischer. Getting Mikey's number? Wow. That's cool. Glad to hear it, I think. I don't know. I don't know what the context is yet. So I'm not sure. Very true. I'll want to hear about that later. We're making stuffed mushrooms. They're almost done, actually. I'm just chopping up the bread. Yeah, humble brags, Mikey. Humble brags. That's okay. How is Judge Fleischer doing? Did you call? Isn't he working? Shouldn't he be working right now? Anyways, let's finish this up.
Nothing further, Your Honor. The pleadings speak for themselves.
Okay. As the court reviewed this file in preparation for today, the court notes the court did state at the prior hearing that allowed defendant to renew his motion upon new facts, which would establish his basis for relief from judgment. I do not see any new facts in the current motion that would cause this court to vacate the judgment of divorce. There's nothing new from what was previously alleged. Court does not believe that the motion meets, again, the threshold necessary for relief from a judgment. And as a result, the court will deny that particular motion. However, the court does note that the motion does raise issues concerning parenting time. Parenting time is always subject to modification, and pursuant to Shade v. Wright, the court has a right to consider that, and that's a much less burden in this particular matter. The court will refer the issue of parenting time and support to the extent that the parenting time is changed and has an impact upon the support, and we'll refer that to the referee for a referee hearing. The court will not award cost at this time. Mr. Schaefer, you can prepare an order denying the motion to set aside relief, and then the court will prepare the order to send the issue of parenting time to the referee.
Thank you.
Thank you.
Thank you.
So, Mikey, was he complaining about you stealing all his views?
The next case is Wilder versus Wilder.
What do you need a moderator for, Lisa? Yeah, we have moderators. They just don't come around all the time. And you have the ultimate moderator right here. I'm the CEO of this operation.
Kevin,
Kevin?
please unmute. Can you hear me, Kevin?
Yes, I can.
Do you know if Leanne plans on appearing this morning?
She's in the office with me.
Okay, calling case 2005-2369 DM, Leanne Wilder versus Stephen Wilder. Today is Monday, September 30th, 2024 at 9:30 a.m.
Court will note the appearance of Mr. Sackrider on behalf of the plaintiff, Mr. Todd on behalf of the defendant. This matter is before the court on the defendant's motion for allocation of proceeds from the sale of the property. Mr. Todd, after I read all the pleadings in preparation for today, I had some questions. As you had stated that your client had made mortgage payments just slightly less than $48,000 in this particular matter. But I note when I saw the other paperwork, I think attached to the answer, that the mortgage was paid off sometime. I don't know if you know when the mortgage was paid off, because I note the paperwork shows that the monthly payments were just under $450. So I'm looking at the time-wise and say, okay,
I'm sorry, I don't think you could get a $450 mortgage on a shed where I live. I swear to God. And John, I know what I'm doing.
hard to reach your $47,928.
Yes, Your Honor. To be 100% honest, I'm not certain when that exact payoff date was. However, I believe that the opposing party is in agreement with that 47,000 number, and we do actually have, actually, I believe it's the opposing parties exhibit 2 that's actually the verification for that.
That's your understanding, Mr. Sackrider, that the $47,928.83 is accurate?
That is our understanding from the June 1st, 2018 Homestead Savings Bank letter. I would note that we did the same calculations for the mortgage, and the note it's not exactly clear when that was exactly paid off, but the only evidence I have is the Homestead Savings Bank, and I don't have any other.
Fuck off. Where's the payout? It is so obvious when you pay off your mortgage. I remember when I worked at the bank, there's paperwork that goes along with that. It's not just something that they like let roll over and then all of a sudden you're like, oh shit, are we still paying that mortgage? No. There's a, what is it called? They discharge the debt. That's what it's called. They discharge the debt. And discharge is a gross word. But they do.
Proofs on that matter.
Okay, thank you. Mr. Todd, you can proceed with the rest of your motion. It
Thank
looks
you,
like
Honor.
the issue is resolved, so the court would order that the defendant would receive a credit for that amount, the $47,928.83 against the proceeds from the sale of the home.
Thank you, Your Honor. Your Honor, for the balance of the motion in this particular case, there were expenses incurred which substantially increased the equity of the property and go beyond standard maintenance. Just highlighting a few, bathroom renovation, a pool liner, the new roof, those all go substantially beyond.
It goes beyond a $450 mortgage. You have a pool? A renovated bathroom? Paisley's crying inside in poor. My rent payment is 3 times that much. God damn it. Hi, MB. We're making stuffed mushrooms. They're almost done.
What standard maintenance would be. We have outlined each expense individually, which comes out to $22,000. Additionally,
okay, Mr. Todd, I did look back at the judgment and reviewed that, the judgment from October 3, 2006, making your client responsible for the maintenance on the house, et cetera. It did not state that he would be reimbursed for any improvements to the house. So how does the court go and say, yeah, you're entitled to these when you did it unilaterally?
Well, and Your Honor, that's exactly why we're here today is, we're not filing a motion for contempt or anything. We're simply having the court weigh in as it amounts to that increase in value. And I guess beyond that, there is a second section of expenses related to sell the property. And we believe that that portion is more explicitly stated in the judgment, indicating the net equity. And those expenses are $2,740. And those are direct expenses related to selling the property.
Okay, thank you. I had that as 1/2 being 1,370, so that would be accurate.
Correct. Yep.
Okay. Mr. Sackrider, any response?
Thank you, Your Honor. I believe the judgment of divorce is pretty clear. This was signed in 2006. The marital home located at 191 Albion Road shall be sold. Next paragraph, it doesn't limit payments to maintenance like defendant stated. It says defendant shall be responsible for all payments associated with the home prior to its sale, including but not limited to mortgages, taxes, insurance, maintenance. There was no receipts or proof of payment attached to that motion. My client does have evidence that at least a portion of those costs being claimed were paid by insurance. It's for all of those reasons, Your Honor, we would ask that this motion be dismissed and that plaintiff be awarded attorney fees in the amount of $1,000 for having to file the motion to show cause to obtain a realtor to force the sale of this property since the judgment of divorce in 2006, as well as respond to this motion for allocation of cost today, Your Honor. Thank you.
Okay, thank you. Well, in this matter, as I stated, the parties do acknowledge the amount of approximately $48,000 to be reimbursed. court does believe that, again, the cost associated with sale, that of one half of that being $1,370 would be reimbursed to the defendant in this matter, because the parties are each responsible for obviously those costs of sale, et cetera. But as to the other expenses sought to be incurred or sought to be, again, reimbursed, again, there's no provision in the judgment that would award that. If he would have, at the time, came and filed the motion, the court could have addressed it at that particular time before he incurred those costs. He did not, so he basically unilaterally incurred those. The court will not order reimbursement of those particular expenses. The court can only enforce the judgment, and that is the written order of the court, and I will do so. I'm not going to award attorney fees at this time, and I'll let you, Mr. Todd, prepare the order.
Thank you, Your Honor. Your Honor, I apologize. One question. There was an $1,000 deposit paid in good faith to sell the property.
I didn't understand that at all from your motion.
Yeah, a little bit odd, I guess, in certain respects, but my client did pay Mr. Sackrider $1,000, I believe, to be put in escrow, in essence, as a good faith showing that he was trying to diligently sell the property. I guess we're just respectfully requesting that $1,000 be returned, or, applied to, returned in essence.
Mr. Sackrider, again, based upon the motion, I have no idea what that money's for, why it was paid. Can you enlighten the court?
I agree, Your Honor. I don't know why it was paid. My staff took a $1,000 payment from him. It was not clear what it was for. The payment is sitting in a trust account. It would become part of the closing of this property, Your Honor.
The court, what it'll do is, I'm not going to make any ruling on that at this time. We'll wait and see how that flushes out at closing, and then we'll deal with it at that time if we need to. Thank you. You're free to go. Have a good day.
Thank you, Your Honor.
Thank you, sir.
Thank you, sir. Thank you, Your Honor. Thank you, everybody, for joining me today as we made these delicious things. Don't touch them, Paisley. They're so hot. So hot. Please don't forget, okay? Don't forget. It's so hot right now. I'm not going to touch them. I'm going to lean back. Lean back. Anyways, those were interesting cases. These do look delicious. They smell even better. And like I said, these are actually really easy to make. I think the total cost for this recipe, including, let's say, the loaf of bread that we'll serve these with, if you were to take these to a party or something like that, that I would call the cost under $5 total to make this. Under $5 Canadian. That's even cheaper American. Tonight is gonna, oh, hold on. Let me check the message from my sister. That'll tell us what's tonight or not. Tonight's gonna be normal time. Never mind. Hey, John. My sister's buying a pachinko machine. Have you ever heard of those? I know you have a bunch of arcade machines. Have you ever heard of a pachinko machine? She's off to buy one of those tomorrow now, not today. Normal time, I think it'll be 6 o'clock, Lisa. You had a pachinko machine, Bill? That's cool. I gotta go to the gym, get a good workout in. I gotta calculate the calories on this. She's only paying like $125 Canadian for it. I was gonna go watch The Baby, but now he's bringing it tomorrow, so it's not a big deal. It's for her hubby, whose birthday is this month coming up. He's off sturgeon fishing right now. Humble brag, I guess. But I am 6 my time is 9 east. 6 my time is 9 east. And yeah, we will see where we get. I don't know what we're gonna watch tonight, but we will we'll get there. I gotta go to the gym, and yeah, I'll post some pictures when she gets it. I was gonna say it's gonna be an even later night tonight because of having to help her, but I don't have to help her, so there we go. I hope you guys enjoyed this. Next week we're gonna be making a new batch of mushroom ketchup. This one is almost out, almost done. This has been the best recipe. Can you imagine the best recipe I've ever tried is from the 18th century? Well, you know, I bet a lot of recipes are from the 18th century if we really think about it. I think tomorrow we might make tortilla pizza, or if I'm feeling very, 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 very with it, then I might make rice, what is it called? I don't know, chicken dumplings, something like that. Anyways, I hope that you had a wonderful day. Thank you so much for joining me. Make sure to check out, I think we've got a Chase, we've got a, Mikey was just talking about Fleischer, we got all these things going on in the world. Thank you again for being here. Remember that I love you, I'm proud of you, and I will see you in the next video. Bye.
Always down and ready to ride.